we have been pretty unsparing in our critique of the Biden administration's response to this ruling by the Supreme Court. And, and I don't think the bar that we had set was particularly high. It was, you had 6 weeks at least to prepare for something, at least perform like even do something performative, but certainly do stuff to heighten the contradiction between the two parties. Now, there is a plan in the House to vote on a series of abortion-related rules. I don't know what is going on with this. And to vote on a series of abortion-related rules or laws in the House just to get Republicans to vote against them. I would like to see some type of resolution that the Senate or the House will not pass a ban. But of course, it's Joe Manchin is staying in front of that stuff, or I should say, is an obstacle to it. But the White House finally came out with something that I think has both the optics of they're doing as much as they can, or they're doing something, I should say, and real legitimate material benefits. We have said many times on this program that the exemption for if a woman's life is in danger was more or less useless.
Yeah.
Because you're forcing hospitals and doctors to make an assessment as to where that state of being, that a woman's life is in jeopardy, starts. Like, does it start where there's a 10% chance, a 5% chance, a 30, a 40, a 50% chance? You could be weeks off from a problem. You could be months off from a problem. I mean, very hard to make that assessment.
And in making that assessment, you're also giving up valuable time that could, be you're wrangling with your lawyers. That's really why it's impossible to actually, create that exception.
And it's going to cause a lot of doctors to just tell women to go somewhere else because they don't want to get arrested. They don't want to serve jail time. They don't want to lose their license. They don't want to pay hundreds of thousands of dollars in fines. This is the same with hospitals. And then, of course, you also have states where there is no exception for the life of a woman. My understanding is that in both those instances, a woman can go to a hospital that receives, that provides Medicare or Medicaid services, which is virtually every hospital in the country. Not every, but almost every, gets federal dollars. And if so, they are subject to the Emergency Medical Treatment and Labor Act, EMTLA, which requires that all patients receive an appropriate medical screening, examination, stabilizing treatment, and transfer if necessary, irrespective of any state laws or mandates that apply to specific procedures. If an emergency medical condition is found to exist, the hospital must provide available stabilizing treatment or appropriate transfer, like I say, to another hospital that has capabilities to provide this. If a physician believes that a pregnant patient, and this is a memorandum summary that Becerra sent, if a physician believes that a pregnant patient presenting at an emergency department is experiencing an emergency medical condition as defined by EMTLA, and that abortion is the stabilizing treatment necessary to resolve that condition. Again, like, you don't have to, like, it's just an emergency medical condition. That physician must provide that treatment. Must. When a state law prohibits abortion and does not include an exception for the life of the pregnant person, or draws the exception more narrowly than EMTLA's emergency medical condition definition, that state law is preempted. Okay, so who determines whether there is an emergency medical condition within the meaning of the EMTLA? Is it a state judge? Is it a state prosecutor or a county prosecutor or a city prosecutor? No, it would be the responsibility, this is a quote, the responsibility of the examining physician or other qualified medical personnel. So in other words, a doctor's or a nurse's determination that a patient is in an emergency medical condition is the final word and arbiter of this. Emergency medical conditions involving pregnant patients may include, but are not limited to, ectopic pregnancy, complication of pregnancy loss, or emergent hypertensive disorders such as pre-eclampsia with severe features. I don't know what that is, but again, at least the last one. But I reiterate, they're not limited to that, and these determinations are made by doctors. All right, we're going to take a quick break. I'm going to see if we can fix my camera, and we'll be right back after this. Cut out that piece, at least in the audio podcast. For those of you watching on video,
absolutely.
What are you going to do, man?
All
right, so to reiterate, and we've gotten some IMs basically saying that it's going to be risk-averse lawyers who are probably going to be engaging in that. There is also an EMTLA whistleblower act. And so there is a lot of force brought to bear on these hospitals. And there is going to be the effectiveness of this order is going to be a function of the Whistleblower Act that is embedded in there.
In what way?
Well, in the sense that if a patient comes in with, let's just say, an ectopic pregnancy, and it's in a state where there is no exception for the life of a mother, just to make this an extreme hypothetical, and the doctor is interested in providing care, or the doctor has been instructed by lawyers at the hospital, we do not do this because we don't want to be embroiled in a state case.
Yeah.
We don't want to be doing that. There's a whistleblower provision within the EMTLA that someone can go and then report on it. And it's really just a question of just how vigorously HHS will fine hospitals found to be in violation.
But the Whistleblower Act could also maybe it could be the reverse, right? In order to maybe go after a doctor, shed light on a doctor who had performed one of these procedures,
no.
and then the state could take action. But I mean,
No. This is a Whistleblower Act within the EMTLA. This is on a federal level. There is no, a whistleblower going and reporting a doctor on a state level, it doesn't matter because federal law, trumps.
Agreed. But as a vehicle to eventually maybe chipping away at this exception that the Biden administration is carving out, doesn't mean that, again, this is the case that Biden's making for not doing other pro-abortion executive orders and actions. So I'm not making that case. I just, in theory, really, maybe the whistleblower clause could allow for. It's
a federal statute, so it's not going to operate on a state level. Okay. But my understanding is that it's up to almost $120,000 per violation of the EMTLA.
Oh, nice. Okay.
And exclusion, I would imagine, either from the hospital or the doctor from Medicaid and Medicare. I mean, so there are major consequences to not following this law. And it really is a question of, and I think early and quick, HHS has to make an example if they come across any one of these cases. But they are putting the memo out there, which sets the predicate. You are now on notice that we are going to start to enforce this. And so,
good way to counteract the bounty system from a lot of these bills in this state law too, right? You got fines on our side now.
Yes, and I think that's the idea. So this is a good first step, and I think there are other things that the the Biden administration can do. You mentioned earlier the idea of using federal buildings as, perhaps a place for abortion providers to work out of. But this is very straightforward and does not have any of the sort of like legal complications that may come with the other move that people are hoping for.